Hey guys, it's your girl, Crystal Nicole. So as you all know, Tory Lanez appeal brief was finally filed on February 26th, and that is what we will be going over today. Now, a lot of these things that you guys will be hearing has already been discussed in the new trial motion, and just like the judge said then, a lot of those arguments would not work for him on a new trial motion, but they would work on appeal. So this is the reason why you guys are seeing a lot of the same repeat arguments that you already heard in the new trial motion, and a lot of this will not be new to you, okay? So with that being said, I will try to go over a lot of these things pretty quickly because, again, we've already discussed a lot of this, okay? So with that being said, let's go ahead and get into this video. Now, a lot of what you all are hearing in this appeal brief was already brought up in the new trial motion, and the judge felt like a lot of those arguments would work on appeal, but not a new trial motion, because he felt like a lot of these errors were due to Tory's counsel not objecting during trial to a lot of these issues or not using the proper objection, etc. So the judge felt like the trial court was not in error, but Tory's counsel was, hence why ineffective counsel is used quite a few times throughout this brief after certain arguments as like a secondary justification for why a reversal should happen if the court decides that the original argument is not sufficient enough. And as stated before, ineffective counsel is a great argument to use on appeal, and they definitely used it. So here is the list of errors they put in this brief, which you can find in the table of contents section of the brief on pages 2 through 3. A would be erroneous admission of evidence. B, prosecutorial misconduct. The erroneous admission of evidence would be the trial court reversibly erred in allowing testimony and evidence concerning Megan's emotions about the incident and its aftermath. The trial court abused its discretion in overruling objections to this testimony. Alternatively, defense counsel was rendered ineffective for failing to object to testimony concerning Megan's emotions and aftermath. The prosecutorial misconduct would be prosecution made improper appeals to emotion and sympathy for the victim. Prosecutors argued facts, not in evidence. Prosecutors denigrated defense counsel and made improper closing argument statements. The trial court erred in admitting evidence of Tory's creative expression, such as tattoos, rap lyrics, and videos, and they chilled Tory's right to testify by trying to use these things against him as evidence. The trial court reversibly erred in admitting statements allegedly made by Tory and allowing Instagram posts to be used that was disclosed in an untimely manner and amounted to inadmissible hearsay that was highly prejudicial. This would be that shade room comment that about people are saying that Kelsey shot Megan, and then Little Jew made the Beats Instagram post claiming that they had matched bullets from Megan's feet to the one in Tory's gun. Then they also included Kelsey's 80-minute interview should not have been allowed to be heard, that they interfered with Tory having conflict-free counsel, which was about that whole Sean Holly and Kelsey accusing her of bribery thing. The sentencing court erred in declining to impose the lowest possible term. So as stated, a lot of these arguments have already been heard in the new trial motion and said that they would work on appeal by the judge himself. So this is why you see them being used again. So in a nutshell, they are saying that the court erred in allowing Megan to give a whole lot of sympathetic testimony that had no bearing on whether or not Tory was innocent or guilty of the crime, and her emotions can't be used as evidence against him, and that the DA heavily relied on this sympathetic testimony in their closing arguments to play on the jury's emotions to prove that Tory was guilty just based off those sympathy speeches alone, which is not allowed to be done. They said Megan's speeches may have worked during the sentencing hearing, but not at trial. And during trial, the jury is supposed to be led off of evidence, not emotions. So ineffective counsel was added here for not objecting during certain parts of her testimony, but doing so at other times. So they're basically saying that either they weren't paying attention or they intentionally let her go on at times when they shouldn't have. You be the judge. So they also argued that the DA argued facts that were not in evidence, and they bring up Kelsey's text to Justin and Justin's alleged claims of what Tory told him after the shooting. Now, Tory's attorneys had tried to have that text excluded as evidence and Justin's statements excluded, since prosecutors couldn't even find him to use him as a witness at trial to back up any claims they would have made that he said during any of their opening arguments, and this would be prejudicial to Tory. But they were allowed to be brought up anyway. So I'm assuming the text is a problem because Kelsey took the stand and said she didn't know why she sent that text, and Justin wasn't there to say anything about that text either. And Justin's claims were that Tory told him he was responsible for the shooting, but he hadn't been shooting at Megan. He had only shot at the ground and in the air. And this just aggravates me because everybody seemed like Kelsey's story was that Tory shot at the ground in the air, definitely in her direction. Justin's story is that he shot at the ground in the air. Sean Kelly said that Tory was shooting in the air everywhere. Never said he shot at Megan, ever. So I just find all these little details interesting. Anyway. So they go on to discuss how the DA also claimed that Kelsey and Justin had obviously been bribed or threatened to not show up, or in Kelsey's case, to change her story. Even though Kelsey had already explained at trial that she had lied because they had been threatening her with jail time and harassing her to come in and speak with them, and that's why she was asking for immunity, because she was afraid they would try to prosecute her for perjury for saying that she had lied to them on the stand. She was never in fear of incriminating herself because she never planned on telling on herself. If Megan wasn't going to tell the truth, why should she? That's basically what she said in her interview with the DA. So you can see why they immediately flipped that narrative quick right after trial was over. Articles were quickly popping up claiming that Kelsey had been paid off and Alex Sparrow was the header of these stories. The DA just repeated it during closing arguments with absolutely no proof of this ever being the case, especially with the amount of times it had been claimed. Not to mention, it's the exact same narrative that Megan tried to spin again recently in her live going off on Party. She again tried to make it seem like they were doing something to all of a sudden make Quan come forward, even though Quan was at trial. Unlike her security, Justin, who tried his best to not have to step into the courtroom. Megan was also the first one claiming payoffs just 4 days after the shooting to the detective, and just a mere 13 days after the shooting on Tory's birthday. She was low-key shading and insinuating that Kelsey had taken hush money and switched up on her, even though this was obviously a manipulation tactic to have explained why Kelsey was no longer living with her, working for her, or her bestie anymore. They had to come up with something to explain Kelsey's abrupt disappearance, because Megan and Kelsey no longer associating right after the shooting didn't make sense unless Kelsey had done something wrong that night. And since Megan refused to admit that she and Kelsey had fought or that she was even sleeping with Tory when it started being said that this is what the argument in the car was about, so they had to come up with something. So a payoff was the story. Megan basically exposed this herself in her recent live when she said that she believed that Kelsey had been paid off or that her life was in danger because Kelsey refused to speak up for herself online in the beginning. Now, this wasn't obvious, blatant lies, seeing as how even in this appeal brief, the lawyers pointed out how Kelsey had jumped online to defend herself immediately after Megan claimed she had been shot. Not to mention, Kelsey and her lawyer denied any payoffs before trial, so why it was being repeated as a fact at trial with absolutely no evidence to back that up is a crime within itself. But I digress. To further expound on this, if Megan thought Kelsey's life was in danger, why was she dragging her in diss tracks claiming that she had people watching her? Had her friends dragging her online, insinuating to her fans that Kelsey had possibly taken money to go against her to further invite more harassment into Kelsey's life if she really believed that this was the case? It just doesn't make sense. So yes, prosecutors erred in trying to pin this on the defense during closing arguments to the jury, as they had zero and presented zero evidence during trial of any payoffs happening or even a bribe. And I believe that this makes a very great argument. So they go on to say how the DA denigrated defense counsel by making statements to the jury about how they felt about the defense intentionally trying to mislead them with insinuations and manipulations, and how they had picked smart jurors, who shouldn't believe certain things, and how they shouldn't be fooled by the attempts of the defense claiming that Tory's DNA was not found when really he couldn't be included or excluded. Things like that. Now, I find this very interesting, given the probation shenanigans they tried to pull. Coming up next. So back in 2020, about 4 days after the incident occurred, Megan had sat down with the detective and she had told him that after the shooting, both Kelsey and Tory came running up to her to help her. Tory was all apologetic. He was claiming he was on probation. He was offering money for her to be quiet and he was offering to take her home, etc. So this was brought up during trial when they were questioning the detective. Now, the defense had got the detective to say that Tory had never been on probation. He said that he couldn't find anything about Tory being on probation. So prosecutors intentionally tried to mislead the jury on the probation issue because, again, they did not want Megan to once again look like a liar. So what prosecutors did was try to use Tory's 2017 Florida diversion case to make it seem like the probation claim could have still been true when Megan said it, because he had been put on diversion and nobody knew if it was still ongoing in 2020, right? Wrong. They did know, because during the sidebar, the defense said that the people's paperwork showed that Tory's diversion, had only been for 2 months in 2017. So they knew he was never on any probation in 2020 when they intentionally asked Detective Stogner at trial whether it was possible Tory still could have been on that diversion in 2020. He said he didn't know because he only knows what goes on in California, not Florida. So it was whatever the courts agreed to, and it was possible he could have still been on probation, but he had no way of knowing that. They were intentionally trying to mislead the jury by using that answer from Detective Stogner to make it look like Megan hadn't lied about the probation claims when they knew good and goddamn well he was never on any probation, playing on the jury's emotion that he was a criminal who could have done something like this. And it definitely worked on the public, because this is a favorite comment of theirs to use when arguing with Tory supporters, that he was on probation, so he would have got a guilty no matter what just for being a felon with an unregistered weapon in a vehicle. Correct? Now imagine how this worked on the jury with that example. This is a great argument to me outside of the ineffective counsel ones, and interesting too, given prosecutors' closing arguments about the defense attempting to intentionally mislead the jury. I wonder how that hypocrisy tastes right about now, because this was just blatant and foul. So here is the other issue that I have with this probation thing being allowed to be talked about at trial as if he was actually on some type of probation. The judge gave instructions to the jury regarding what a diversion is, and he said a diversion is an agreement between prosecutors and the accused that if he satisfies certain obligations, the charges will be dismissed. Diversion and probation are not the same thing. Let's say that again. Diversion and probation are not the same thing. So, if diversion and probation are not the same thing, and the accusations have to do with Tory being on probation and not a diversion program, then why is this being discussed at trial when one has nothing to do with the other? Just doesn't make sense. Furthermore, once again, prosecution. Why would you be questioning the detective on whether or not this diversion could still be going on in 2020 when you're looking at a paperwork right in front of you that says that this diversion ended just 2 months after it began? If you already knew the answer to that question, why are you asking him for his response on it? And like he said, well, I'm a Cali detective, not a Florida one, so I know things that go on in Cali, not Florida. I don't know what they did on that case. So yeah, I mean, it's a possibility he could have still been on probation. Like, All of this should have been stricken. All of this should have never been asked, never been said, none of it, since you had the paperwork in front of you showing you that he was not on probation, and that was the claim. We are not here about him being on a possible diversion at the time. Like, all of this was wrong and was clearly trying to manipulate the jury, because if you weren't trying to make it seem like Tory was a criminal who had the capacity to commit a crime like this due to this diversion, why were y'all even bringing this up or questioning the detective in this type of way regarding it, when, again, one has nothing to do with the other? You knew he wasn't on probation. So why are we trying to prove Megan's claims to be true when you yourselves knew that it was false? Which brings us to Sean Hawley and this bribery thing, because this was also an issue because you impeded Tory's right to his own counsel by trying to accuse her of bribery when, again, y'all had told Sean Hawley well before trial that y'all did not believe that she had anything to do with any alleged bribery claims that Kelsey had made, just for y'all to bring it up more than a few times during trial, causing Sean Hawley to have to fully step down as Tory's attorney, so there wouldn't be a conflict of interest. Y'all seem to have a habit and pattern of doing shady little things like this during trial, and it's probably because y'all didn't have not a lick of evidence to support any of these charges, for real. But I digress. So they go on to talk about the hearsay evidence that was allowed to be entered, and that would be that Instagram comment left by Joshua Ferris, which is, I believe, Tory Lanez's social media account manager. Correct me if I'm wrong. And then that Instagram comment from Little Jew made the beat about the bullets being matched from Tory's gun to the one in Megan's feet. Now, for the life of me, I just don't understand why this was even introduced or even used as evidence. The prosecution could have presented their own evidence that this was true if it was true. Oh, but wait, I forgot the fragments from Megan's foot went missing, and they had no idea who the gun belonged to out of the four, besides not objecting to it being Kelsey's at pretrial. So I guess that's why. Outside of that, I have no clue why they thought this was evidence of anything besides a producer talking shit online. I just don't get it. And they say that this Instagram post was the people's evidence that the gun belonged to Tory because Little Jew made the beat, said so. This was their entire evidence that the gun belonged to Tory, because they definitely couldn't prove that with DNA. And maybe had they attempted to even take the other three people's in the car DNA to at least do a process of elimination on who the gun could have belonged to, maybe we would have had this answered by now. But either way, we all know that Little Jew made the beat was lying when he made this post, and we all know the reason why he would be lying for Megan. No need to repeat that again. It's been repeated
Same
enough.
nigga that you did all the tags for the beats. You let that nigga tag, let him beat. You let me give him that when we meet. Even that, I kept discreet. I asked you to your face, did you fuck them niggas? And you swore on your mother.
They add ineffective counsel here as well, because even though they objected, they didn't specifically object to it being hearsay. And there's no good reason for why they didn't object on the proper grounds, and I agree with this. And I failed to mention that they did also add ineffective counsel for the probation thing as well. So yeah, I told you they added ineffective counsel a lot. They also go into allowing Kelsey's interview to be played. Oh, I'm sorry. I forgot to add that the reason why that Instagram comment that was left by Joshua Ferris saying that people were saying Kelsey was the shooter, they were saying was, number one, is hearsay, because obviously they never proved who wrote that comment at trial. They just had the detective get up there and claim that Tory was the one who wrote it. And the issue with this is that they entered this into evidence 4 days before the trial. So it didn't give Tory and his team time to go and, do their investigation and finding out on who actually wrote the comment and blah, 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 all that. So that is what the big issue is regarding that Instagram comment that was used as evidence. So we have already gone over quite a few times why Kelsey's 80-minute interview shouldn't have been allowed to be played for the jury in full. And we've also gone over the tattoos and music videos and lyrics, etc., being used against Tory as evidence to chill his right to testify. So we're not going to go over that again. They did bring up the court erred in giving proper instructions to the jury about the charges and what that all meant. And they also went over the court erred in declining to impose the lowest possible term. So, with that being said, that's pretty much the gist of everything that was stated in this appeal. So, I'm going to go ahead and give my final thoughts, and then that will be the end of this video. So the first thing I want to say is that I think a lot of people think that an appeal is like a new trial where you get to argue your client's innocence again, but just to a higher court, and that's not what this is. They are only arguing trial errors made that resulted in the innocent or guilty verdict that, had not been made, may have swayed the verdict. This is not for them to go over all of Megan's lies or Kelsey's, etc. It's not to break this case down from beginning to end again to show how their client was railroaded. That time has passed. They can introduce new evidence if they have it, but this is not a trial. They are arguing errors made at trial, hoping to get a reversal on the verdict. It's almost similar to what you would do in a new trial motion, which is why you see these arguments again and why they touch on why a new trial should have been granted in this appeal. Excuse me. So I can understand why a lot of people think that these arguments may be weak because they failed during the new trial hearing, and possibly because you're expecting to hear some damning exposure of Megan in this. If his team had something to expose Megan, they would have presented it when they presented Quan's statement as new evidence, and they didn't. So what they put in this appeal is what we are working with. However, these arguments are what you are supposed to give during an appeal, and whether you agree on their strength or not, this is the process, as they have to bring up things related to the actual trial. Excuse me, and they did that. And they made sure to include ineffective assistance multiple times throughout, since the trial judge also claimed a lot of counsel issues instead of court error issues that should be brought up on appeal, and that's exactly what they did. So I do believe that they brought up quite a few good arguments, and we will have to see how this goes. The attorney general still has to respond, so we will see what they have to say also. Now, what I will say again is that the prosecution had no evidence proving Tory's charges. They did not prove he was the owner of the gun. It being in his car and found where he was sitting was enough. I am so sorry. I have something in my eye. Ow. Was enough for suspicion that it was his, but they never actually proved it was his, versus the other 3 individuals in the car. They never took anybody else's DNA to do a process of elimination. They only offered up an Instagram post and the Shade Room post or TMZ post claiming that Tory was the owner, and they do not count. They never proved he assaulted Megan with that gun. The only witness they had was Megan, and nobody backed up her story. The eyewitness never said Tory shot at Megan. Kelsey never took the stand and said Tory shot at Megan. Quan never said Tory shot at Megan. Nobody said Tory yelled "dance B," and nobody had Megan just walking away from the car when shot. All prosecution had was Megan's say-so, conflicting witness accounts, no video footage, and no DNA. They had 2 people who had tested positive for GSR, so they couldn't just form a conclusion that it just had to be Tory with that info. So how did they prove that Tory was the one who shot Megan? They never proved that he negligently shot her, as even using Sean Kelly's testimony as the key to that charge, he also never had Tory as the one who pulled out the gun and started shooting first. He faithfully maintained that it was Kelsey who was flashing first, and whosoever pulls and shoots the gun first is responsible for negligently discharging a firearm. Tory trying to take it away and him possibly firing shots during that scuffle that could have hit Megan does not fit that charge, nor does it prove his movements caused her injury versus Kelsey. So no matter how many times they yell, it was 47 pieces of evidence. And none of those pieces of evidence conclusively proved anything against Tory. That's why they can't never name even one out of those 47 pieces that did it. Not even a confession in writing or recording. And that's what they would need at this point to convince me that he did this, because nothing adds up. The new statement from Quan, plus the ineffective counsel and the trial errors listed, in my opinion, should definitely grant a reversal. But given how everything has gone down, and Megan's overconfident statement that everything Tory puts in is getting denied, one can never be too sure. So let's just keep hoping for the best, and I'll see you all when the Attorney General responds. With that being said, free Tory.